may have precipitated the matter filed by the Honorable Senator Omtata. At the time, the Honorable Kajwang queried the propriety of operationalizing all the revenue-raising measures proposed in a finance bill in line with the Provisional Collection of Taxes and Duties Act 1959, in light of the provisions of the Constitution and the Public Finance Management Act 2012. The Hansard records that several current members of the House ventilated on the point raised by the Honorable Kajwang then, including the Majority Leader, the Honorable Kimani Ichung'wah MGH MP, the Honorable John Mbadi, and the Honorable Makali Mulu MP. The High Court issued its judgment in Okiya Omtata Okoiti versus Cabinet Secretary, National Treasurer, and three others, 2018 KLR, Kenya Law Reports, on 19 September 2018, and gave the following orders, and I quote: a declaration that by presenting the Finance Bill 2018 to the National Assembly on 14th June 2018, while the financial calendar ends on 30th June 2018, the Cabinet Secretary violated Section 37 of the Public Finance Management Act 2018, which sets the 30th April deadline for the Cabinet Secretary to table the budget estimates and any other bills. Any other bills required to implement the national government budget for approval by the National Assembly. Order, Honorable Women Rep Kisi and your colleague. You are distracting the chair from delivering the ruling. A declaration that the Provisional Collection of Taxes and Duties Act number 44 of 1959, Chapter 415 of the Laws of Kenya is unconstitutional and therefore invalid, null, and void. A declaration that the Finance Bill 2018 or any parts or provisions thereof, including on taxation, cannot be implemented before the bill becomes the Finance Act and it goes through the parliamentary legislative process laid out in the Constitution for approval and adoption by Parliament and assent by the President. Arising from these orders of the Court and ostensibly informed by the debate that ensued on the point raised on the propriety of approving provisional collection of taxes and duties, the House subsequently amended the Public Finance Management Act in July 2019 through Statute Law Miscellaneous Amendment Act 2019 to introduce Section 39A in the Act. The section requires the Cabinet Secretary to submit the Finance Bill before 30th April every year and that it be passed before the end of the financial year on 30th June. The section clarified the manner in which a Finance Bill ought to be introduced, considered and passed by the House. It provides as follows, and I quote: the Cabinet Secretary shall submit to the National Assembly on or before 30th April the Finance Bill setting out the revenue-raising measures for the national government. 2. Following submission of the Finance Bill by the Cabinet Secretary, the relevant committee of the National Assembly shall introduce the bill in the National Assembly. 3. The National Assembly shall consider and pass the Finance Bill with or without amendments in time for it to be presented for assent by 30th June each year. Any recommendations made by the relevant committee of the National Assembly or resolution passed by the National Assembly on revenue matters shall: A, ensure that the total amount of revenue raised is consistent with the approved fiscal framework. B, take into account the principles of equity, certainty, and ease of collection. C, consider the impact of the proposed changes on the composition of the tax revenue with reference to direct and indirect taxes. D, consider domestic, regional, and international tax trends. E, consider the impact on development, investment, employment, and economic growth. F, take into account the recommendations of the Cabinet Secretary as provided under Article 114 of the Constitution. And G, take into account the taxation and all other tariff arrangements and obligations that Kenya has ratified, including taxation and tariff arrangements under the East African Community Treaty. This leads us to the second issue of an apparent variance in the provision of Standing Order 244C and the dictates of the judgment and the provisions of the Public Finance Management Act 2012. Honorable members, as I had indicated, my attention was drawn to the existence of an apparent variance in the provisions of Section 39A and Section 40 of the Public Finance Management Act 2012 with regard to the manner of introduction and consideration of a finance bill. Section 40 of the Act provides as follows. Each financial year, the Cabinet Secretary shall, with the approval of Cabinet, make a public pronouncement of the budget policy highlights and revenue-raising measures for the national government. 2, in making the pronouncement under Section 1, the Cabinet Secretary shall take into account any regional or international agreements that Kenya has ratified, including the East African Community Treaty, and where such agreements prescribe the date when the budget policy highlights and revenue-raising measures are to be pronounced, the Cabinet Secretary shall ensure that the measures are pronounced on the appointed date. On the same date that the budget policy highlights and revenue-raising measures are pronounced, the Cabinet Secretary shall submit to Parliament a legislative proposal setting out the revenue-raising measures for the national government together with a policy statement expounding on those measures. Following the submission of the legislative proposal of the Cabinet Secretary, the relevant committee of the National Assembly shall introduce a finance bill in the National Assembly. Any of the recommendations made by the relevant committee of the National Assembly or adopted by the National Assembly on revenue matters shall A, ensure that the total amount of revenue raised is consistent with the approved fiscal framework and Division of Revenue Act, take into account the principles of equity and ease of collection, consider the impact of proposed changes on composition of the tax revenue with reference to the direct and indirect taxes, consider domestic, regional, and international tax trends, consider the impact on development, investment, employment, and domestic growth, take into account the recommendations of the Cabinet Secretary and Article 114 of the Constitution, and take into account the taxation and other tariff agreements and obligations that Kenya has ratified, including taxation and tariff agreements under the community. The recommendation of the Cabinet Secretary in subsection 5F shall be included in the report and tabled in the National Assembly. A plain reading of Section 43 and 44 of the Act indicates that the Cabinet Secretary for the National Treasury and Economic Planning is required to submit a legislative proposal setting out the revenue-raising measures for the national government on the same day that he or she makes a pronouncement of the budget policy highlights and revenue-raising measures. This would seem to be at variance with the express obligation under the more recent Section 39A, which requires that the Cabinet Secretary to submit a finance bill to the House not later than 30th April every year, in compliance with the orders of the court in Okio Mtato Koiti versus Cabinet Secretary, National Treasury, and 3 others. Take your seats, members. The nearest seat, Honorable Kwame, the nearest seat. Well done. That is the nearest you can find. Honorable members, in my view, a purposive interpretation to bridge the apparent conflict between the two provisions requires the application of established principles of statutory interpretation and reference to the practice, precedent, and conduct of the Cabinet Secretary and House since the court judgment was issued. Honorable members, it's a canon of statutory interpretation that when faced with conflicting provisions, preference must be given to a specific provision as opposed to a general provision. Additionally, the last-in-time principle, where the most recent addition to a statute is given precedence over a provision that was enacted earlier, should be applied. From my reading of Section 39A and Section 43 and 4, it is noteworthy that Section 39A specifically refers to the introduction, consideration, and passage of a finance bill. On the other hand, the provisions of Section 43 and 4 only generally refer to a legislative proposal. Additionally, Section 39A is the most recent addition to the Act and represents the most specific and current position of the House on the manner of consideration of a finance bill. Honourable members, the practice and conduct of the Cabinet Secretary and the House since the decision in Okiya Omtatah Okoiti versus Cabinet Secretary, National Treasurer, and 3 others, 2018 Kenya Law Reports, and the amendment of the Public Finance Management Act 2012 has been consistent. Notably, in 2020, the Cabinet Secretary submitted the finance bill together with the budget estimates on 30th April 2020. The bill was published on 5th May 2020 and was considered and passed by the House on 23rd June 2020. It was assented to by the President on 30th June 2020. The Cabinet Secretary presented the budget statement for the financial year 2021 on 11th June 2020, well after the publication of the bill. In 2021, the Cabinet Secretary submitted the finance bill together with the budget estimates on 29th April 2021. The bill was published on 5th May 2021 and was considered and passed by the House on 24th June 2021. The particular bill was assented to by the President on 29th June 2021. The Cabinet Secretary presented the budget statement for the financial year 21-22 on 10th June 2021, well after the publication of the bill. In 2022, on account of the general elections scheduled for August 2022, the Cabinet Secretary submitted the finance bill together with the budget estimates on 7th April 2022. This was on the same date that he presented the budget statement in the House. The bill was published on 8th April 2022 and was considered and passed by the House on 7th June 2022. In keeping with the provision of Section 39A of the Public Finance Management Act 2012 and the new court judgment, the Finance Bill 2022 was assented to by the President on 21st June 2022. Honourable members, from the foregoing, it's clearly apparent that the Cabinet Secretary and the House have adhered to the letter of the orders of the court in Okiya Omtatah Okoiti versus Cabinet Secretary, National Treasurer, and 3 others, 2018 Kenya Law Reports, and Section 39 of the Public Finance Management Act 2012. This clearly signifies that Section 39A of the Public Finance Act 2012 is the operative provision with regard to the introduction, consideration, and passage of a finance bill. Honourable members, the third issue was with regard to the effect of the presentation of the budget statement on the consideration of a finance bill. Section 40 of the Public Finance Management 2012 requires the Cabinet Secretary to make a public pronouncement of the budget policy highlights and revenue-raising measures of the national government. In doing so, the Cabinet Secretary is required to take into account international obligations entered into under the East African Community Treaty. The House is aware that the East African Community partner states have agreed to present and table their budget statements to their respective parliaments every second Thursday of June. It is largely a ceremonial exercise which, particularly in our case, does not take away that all documentation relating to the budget is required to be submitted well in advance of the presentation of the budget statement. Indeed, as members are aware, no question or comment is permitted during the presentation of the statement. As a budget-making house, we are seized of the estimates and the finance bill, latest the 30th of April every year. Save for compliance with the applicable statutory timelines, the House is left to its own devices on how to consider the budget documents submitted to it. The House is under an obligation to prioritize the consideration of a finance bill with a view of passing it before the lapse of the 30th June deadline imposed by Section 39A of the Public Finance Management Act 2012. It should not be lost to honourable members that the procedures of the House cannot be left to the whim of another arm of government. The House is therefore at liberty to prioritize consideration of a finance bill before or after the presentation of the budget statement by the Cabinet Secretary for the National Treasury. As I conclude, I note that the variance in the sections 39A, 43 and 4 of the Public Finance Management Act extends Standing Order 244C, which I gave rise to the point raised by the Honourable Member for Arieda. The Honourable Otienda Molo, EBS Senior Counsel MP. The Standing Order does not take into account provisions of Section 39A and the requirement for the submission and passage of the Finance Bill before 30th of April and 30th June, respectively, every year. Honourable members, having guided that Section 39A is the operative provision with regard to the consideration of a Finance Bill, I direct the Procedure and Rules and House Rules Committee to note the variance and include the Standing Order in the items earmarked for review when it next proposes amendments to the Standing Orders. In summary, therefore, honourable members, my guidance is as follows. Section 39 of the Public Finance Act 2012 requires the Cabinet Secretary for the National Treasury to submit the Finance Bill before 30th April every year and that the bill be passed before the end of the financial year on 30th June. The section governs the manner in which a finance bill ought to be introduced, considered, and passed by the House. 2, it is a canon of statutory interpretation that when faced with conflicting provisions, preference must be given to a specific provision as opposed to a general provision. Additionally, the last-in-time principle where the most recent addition to a statute is given precedence over a provision that was enacted earlier should be applied. Section 39A of the Public Finance Management Act 2012 specifically refers to the introduction, consideration, and passage of a finance bill and represents the most specific and current position of the House on the manner of consideration of a finance bill. That the Cabinet Secretary and the House have consistently adhered to the orders of the court in Onkio Mtata Okoiti versus Cabinet Secretary, National Treasury, and 3 others, 2018 Kenya Law Reports, and Section 39A of the Public Finance Management Act 2012. This clearly signifies that Section 39A of the Public Finance Act 2012 is the operative provision with regard to the introduction, consideration, and passage of a finance bill. That the House is under an obligation to prioritize the consideration of a finance bill with a view of passing it before the lapse of the June 30th deadline imposed by Section 39A of the Public Finance Management Act 2012. The House is therefore at liberty to prioritize consideration of the finance bill before or after the presentation of a budget statement by the Cabinet Secretary for National Treasury. That the Procedure and House Rules Committee notes the variance between Standing Order 244 and Section 39 of the Public Finance Management Act and include the Standing Order in the items earmarked for review when it next proposes amendments to the Standing Orders. The House is guided accordingly. And allow me to thank the Honourable Otienda Molo for raising the issue so that we can give clarity on the matter going to the future. Thank you. Ordinarily we don't debate or comment on the ruling and direction of the chair. We will let it lie there. Honourable Otienda Molo, let the chips lie where they fell. Otienda Molo.
Thank you. Mr. Speaker, I actually just wanted to thank you. Okay. But in so doing, I wanted to let the majority leader know, because when we raised this matter, he threw words as he usually does, alleging that I was part of the case that you've actually alluded to. So I wanted him to know that I was not part of the case and I was not aware of it. But Mr. Speaker, secondly, I take your guidance, and I think the House Business Committee and the House Rules Committee should take your guidance very seriously. We have amended our Standing Order twice since that decision of the court on 6th of June 2020 and 7th of June 2022. This should have been factored. But last, Mr. Speaker, because the Speaker is always right, Mr. Speaker, I urge that the House Rules Committee, in considering your guidance, do actually consider the fact that although the decision says that the matter must be published and introduced, it does not say it must be debated before the budget. I want to suggest that it would be in order to have the budget, then the contents of it are then debated in the finance bill. That is, not to bring the second reading before the budget, so that the budget is heard, then we have the second reading, which is the debate, then we move logically, Mr. Speaker. But lastly, Mr. Speaker, I do now have a point of order on the next business, which is order number 13.
Order, Honorable Tiende. Order, Honorable Tiende. You are certainly taking unhelpful shortcuts. Honorable members, I will not allow you, Honorable Mbadi. I have given order, Honorable Mbadi. This matter was raised by Honorable Tiende. I've bent backwards to allow him to make a comment, and I have thanked him for raising a matter that goes to align the Act with our standing orders in the next review. You will present your views to the committee when it meets. Honorable members, before we go to the committee of the whole, I want to invite the majority leader to move a procedural motion on the sitting time. Thereafter, I'll give you some guidance on how to proceed in the committee of the whole before we go into the committee. Majority leader.
Procedural motion, extension of sitting time.
Thank you, Honorable Speaker. Honorable Speaker, with your indulgence, because when you gave the Honorable Tiende Molo the right of reply, he did mention my name. Just to clarify to him that whatever I said, because it was not on record, was not in bad faith. Because I hear you severally refer to the Honorable Tiende Molo as senior counsel, and I expected the senior counsel he would be privy to matters that are in the courts, and therefore ordinarily senior counsel will know what issues are in the court, especially in court weighty matters like that issue of the Umtata case, petition 253 of 2018. Honorable Speaker, allow me to move that pursuant to the provision of Standing Order 33A, this House orders that should the time appointed for adjournment of the House today, Tuesday 20th June 2023, be reached before conclusion of the business appearing under order number 14 of today's order paper, being Committee of the Whole House on the Finance Bill 2023, the sitting of the House shall stand extended until the conclusion of the said debate. And Honorable Speaker, I don't need to say much about this, because as you alluded, it's something we discussed in the House Business Committee, and the House Business Committee did direct that we have this procedural motion for today, tomorrow, and Thursday, as you have rightly communicated earlier. And Honorable Speaker, I beg to move. Let me ask the Honorable Junet Mohammed to second.
Mr. Speaker, I stand to second, but seconding Mr. Speaker, as you said, or as you directed in the House Business, we discussed in the House Business Committee that there is a lot of business before us. But Mr. Speaker, Kenyans must know that members of parliament are working. There are no other people in this country who sit up to midnight to do work other than members of parliament, Mr. Speaker. Mr. Speaker, many times members of parliament are bashed outside there, that, oh, they earn for nothing, they earn a lot of allowances, they earn this and that. These are the only people, Mr. Speaker, who sit up to midnight to do the business for this country, Mr. Speaker. And when we are sitting up to midnight, there is no allowance. We are doing it for free, Mr. Speaker, because we want to serve our country. So, Mr. Speaker, I want to beseech members to stay. There is a lot of food, I'm told, at the cafeteria. You can eat. You can drink a lot of water. And then those who have other business after house, they can suspend it for today until another day, so that we can conclude these financial businesses of the country properly, Mr. Speaker, so that Kenyans can have money in their pockets, if at all it will be. But myself, I doubt. But thank you very much, Mr. Speaker.
Thank you, Honorable Junet. Honorable members, I propose the question, which is that, pursuant to the provision of Standing Order 33A, this House orders that should the time appointed for adjournment of the House today, Tuesday, 20th June 2023, be reached before conclusion of the business appearing under order number 14 of today's order paper, being Committee of the Whole House on the Finance Bill 2023. The sitting of the House shall stand extended until the conclusion of the said business. I now put the question. You want to contribute on this? Is it the mood of the House that we put the question? And now put the question. You can respond without drama. That pursuant to the provision of Standing Order 33A, this House orders that should the time appointed for adjournment of the House today, Tuesday, 20th June 2023, be reached before conclusion of the business appearing under order number 14 of today's order paper, being Committee of the Whole House on the Finance Bill 2023, the sitting of the House shall stand extended until the conclusion of the said business. As many as of that opinion say aye. Aye. Will those of the contrary opinion say nay? Nay. The ayes have it. Honorable members, before we get to the committee, allow me to give some guidance on consideration of proposed amendments to the Finance Bill, National Assembly Bill number 14 of 2023. Honorable members, this communication relates to the business appearing under Order 14 in today's supplementary order paper, Tuesday, 20th, 2023, being Committee of the Whole House on the Finance Bill, National Assembly Bill number 14 of 2023. Before the House proceeds with the Committee of the Whole House, I wish to provide guidance relating to the consideration of the proposed amendments at the Committee of the Whole House. Honorable members, you may recall that on Thursday, 15th June 2023, after conclusion of second reading of the said bill, I did notify the House that members desirous of proposing amendments to the Finance Bill 2023 were at liberty to submit the amendments to the clerk in the manner provided for in the standing orders. Honorable members, Standing Order 133, procedure in Committee of the Whole House on a bill provides as follows with respect to the submission of the amendments on bills. No amendment shall be moved to any part of a bill by any member other than the member in charge of the bill, unless written notification of the amendment shall have been given to the clerk 24 hours before the commencement of the sitting, at which that part of the bill is to be considered in the committee. In this regard, honorable members, at the close of the timeline prescribed in Standing Order 133-2, the clerk had received several proposed amendments to the said bill, originating from the Departmental Committee on Finance and National Planning, other select committees, and individual members. Indeed, as you may have observed, the notices annexed to today's order paper contain several amendments that have been proposed to the said bill. For certainty, honorable members, other than the Departmental Committee on Finance and National Planning, the following chairpersons of committees and individual members have proposed amendments. The Chairperson Select Committee on Delegated Legislation, the Chairperson Departmental Committee on Blue Economy, Water and Irrigation, the Chairperson Departmental Committee on Transport and Infrastructure, the Honorable Samuel Atandi, MP, the Honorable Ditmas Barasa, MP, the Honorable John Waluke, MP, the Honorable Dr. Undo Ojambo, MP, the Honorable Lesuda Naisula, MP, the Honorable Mohammed Daud, MP, the Honorable Jared Okello, MP, the Honorable Caleb Amis, MP, the Honorable Dr. James Nyikal, MP, the Honorable Dr. Makali Mule, MP, the Honorable Anton Oluoch MP, the Honorable Innocent Mugabe MP, the Honorable Wanami Wamboka MP, the Honorable Peter Kaluma MP, the Honorable Majimbo Kalasinga MP, the Honorable Robert Mbui CBS MP, the Honorable Caleb Mutiso MP, and the Honorable Geoffrey Ruku MP. Honorable members, as you may be aware, it is now an established practice under the Constitution that when considering any matter that has a financial implication on public funds, the House is bound by the provisions of Article 1142 of the Constitution. For clarity, Article 1142 of the Constitution provides, and I quote, if in the opinion of the Speaker and of the National Assembly, a motion makes provision for a matter listed in the definition of a money bill, the Assembly may proceed only in accordance with the recommendation of the relevant committee after taking into account the views of the Cabinet Secretary responsible for finance. Honorable members, under Clause 3 of Article 114, a money bill includes matters that contain provisions dealing with inter alia taxation, the imposition of charges on a public fund, the appropriation, receipt, custody, investment, or issue of public money, and the raising and guaranteeing of any loan or its repayment. In this regard, a finance bill being one that deals with taxation is clearly a money bill. Honorable members, therefore, consideration of the Finance Bill 2023 squarely falls within the confines of Article 114 of the Constitution and other provisions relating to processing of legislation in the House. The provisions of Article 114 of the Constitution are also anchored in Section 39A of the Public Finance Management Act 2012, which state in part, and I quote, Section 39A, submission, consideration, and passing of finance bill. Any recommendations made by the relevant committee of the National Assembly or resolution passed by the National Assembly on revenue matters shall consider the impact of the proposed changes on the composition of the tax revenue with reference to direct and indirect taxes, consider domestic, regional, and international tax trends, consider the impact on development, investment, employment, and economic growth, take into account the recommendations of the Cabinet Secretary as provided under Article 114 of the Constitution, and take into account the taxation and other tariff arrangements and obligations that Kenya has ratified, including taxation and tariff arrangements under the East African Community Treaty. Additional honorable members, Standing Order 133.5 provides that no amendment shall be permitted to be moved if the amendment deals with a different subject or proposes to unreasonably or unduly expand the subject of the bill, or is not appropriate or is not in logical sequence to the subject matter of the bill. In this regard, I have analyzed the amendments proposed to the Finance Bill 2023 and noted that some contain proposals touching on matters listed in the definition of a money bill pursuant to the provisions of Article 114 of the Constitution. For the record, the amendments proposed by the Departmental Committee on Finance and National Planning are not part of those that I have isolated for guidance, as they were processed in the manner contemplated under Article 114 of the Constitution. Having applied my mind on various proposed amendments, I have determined that certain amendments are either similar to or they are fully accommodated by those proposed by the Departmental Committee on Finance and National Planning. In this regard, such amendments will be proceeded with in the Committee of the Whole House. On the other hand, honorable members, there are proposed amendments that, in my opinion, fall within the meaning of a money bill in terms of Article 114 of the Constitution. As you may have clearly noticed in the order paper, I directed the clerk to publish such amendments with a disclaimer subject to provisions of Article 114 of the Constitution placed under each of the affected amendments. As stated earlier, honorable members, whenever a motion or a proposed amendment is subjected to Article 114 of the Constitution, it is expected that such proposal may only be proceeded with if there is concurrence of the National Treasury through the Departmental Committee on Finance and National Planning. In the absence of the evidence that the affected amendments were processed in the manner contemplated in Article 114 of the Constitution, the Speaker is left with no option but to direct that the Committee of the House shall not consider any of the amendments or parts of amendments that have been published in the order paper with a disclaimer. Consequently, members should note that a member seeking to delete a clause need not have an amendment proposing the deletion of a clause. This is because a member is only required to raise and oppose a clause as published in the bill. This effectively enables any member to prosecute his or her opposition to a clause despite the requirements of Article 114 of the Constitution. Further, honorable members, I hasten to inform the House that all proposed amendments for which requirements of 114 of the Constitution do not apply are annexed in the order paper. Honorable members, a number of proposed amendments have since been received from 3 members, namely the Honorable Joshua Kandia MP, the Honorable George Sunguya MP, and the Honorable Basil Ngui MP, outside the time provided for in the standing orders. For clarity, Standing Order 133.2 provides as follows: no amendment shall be moved to any part of a bill by any member other than the member in charge of the bill unless written notification of the amendment shall have been given to the clerk 24 hours before the commencement of the sitting at which that part of the bill is to be considered in committee. The House will therefore note that the proposed amendments are time-barred, those 3. However, I note that some of the amendments have been incorporated in the amendments proposed by the Committee on Finance. Honourable members, I give this direction with full consciousness that the intention of Article 114 of the Constitution is not to curtail the legislative mandate of the House. The article merely seeks to ensure that inasmuch as this House reserves the power to determine revenue-raising measures, it does not commit the executive without taking cognizance of the fiscal policy and considerations of the national government. The House is accordingly guided. I thank you. Minority Leader.
Mr. Speaker, I rise on Standing Order 131. But before I go there, Mr. Speaker, I want to say that before I go there, Mr. Speaker,
Yes.
I want to say that just as I mentioned earlier today in the House Business Committee, Mr. Speaker, our understanding of the provisions of Article 114, Sub-Article 2, is that the House does not require the concurrence of the Cabinet Secretary, but simply requires to take into consideration the views of the Cabinet Secretary, which views it can either accept or reject. Mr. Speaker, for that purpose, Mr. Speaker, I am of the view that we can still prosecute all the proposed amendments. Mr. Speaker, I want to go to the second issue, if you may listen, if you may give me attention.
Yes.
If members could give me attention.
Order, honourable members. You will listen to the Minority Leader in silence.
Mr. Speaker, Standing Order 131, and I want to read it for the avoidance of doubt. And as I do so, Mr. Speaker, this notion that we are in a hurry should also be dispensed with, because I don't think we are in a hurry. We have all the time to deal with the issues.
Yes.
Yes, Mr. Speaker.
No.
Mr. Speaker, Standing Order 131. Standing Order 131. Provides that where a bill has been read a second time and before commencement of the Committee of the Whole, as we are about to do, Mr. Speaker, amendments have been proposed to it, which in the opinion of the Speaker require harmonization. The Speaker may direct any member proposing an amendment to the bill to appear before the relevant departmental committee dealing with the subject matter of the bill to present his or her proposed amendments, and the committee shall submit a report to the House on the result of the exercise before the Committee of the Whole House is taken. Mr. Speaker, you will notice from the Standing Order 131 that the amendments that have been proposed go to the core of the bill, and some have got far-reaching ramifications. I just want to plead with you, because we haven't been told if at all a window was provided to the Committee on Finance, chaired ably by Honorable Kimani Kuria, to undertake this harmonization process. In fact, in parliamentary parlance, it is referred to as winnowing. That would then make the work of the whole House easier, Mr. Speaker. Mr. Speaker, there is much more to it, Mr. Speaker, because, Mr. Speaker, in the past, previous speakers, and in particular Speaker J.B. Muturi, has ruled when faced with similar situations where there have been very many amendment proposals to a bill. He has ruled that the winnowing exercise be undertaken before the Committee of the Whole can commence. But he has even gone further, Mr. Speaker. If you go to Article 118 of the Constitution, Article 118 of the Constitution, Mr. Speaker, imposes a duty on this House, without reading it, imposes a duty on this House to undertake proper public participation on any bill before it can be dispensed with or before it can be processed. Mr. Speaker, the upshot of this, and again this is buttressed by Standing Order 127.3, which I will read. 127.3, Mr. Speaker, and I seek members' indulgence. 127.3, the department committee to which a bill is committed shall facilitate public participation on the bill through an appropriate mechanism, including B, holding public hearings, and many other things. Mr. Speaker, going by the number of amendments being proposed, firstly by the Committee on Finance, and secondly by various other members and chairs of other committees, it would appear that the character of this bill is likely to change in a comprehensive manner, Mr. Speaker. And we are likely to be transacting business on matters which the public have not been given an opportunity to make their contribution. In other words, on a matter on which the public has not participated, Mr. Speaker. Mr. Speaker, I want to just give two examples of bills which had not only been referred back to the Committee for Harmonization, which is winnowing, but actually were ordered to be republished by the Honorable Speaker J.B. Muturi. Mr. Speaker, one such bill is the gaming bill, Bill number 35 of 2019. The second bill is the Universities Amendment Bill of 2021. In those two instances, in respect of those two bills, Speaker Muturi, having assessed the enormity of the proposed amendments and the likelihood of them changing fundamentally the character of the original bill, and bearing in mind the requirements and the dictates of Article 118 of the Constitution on public participation, buttressed by Standing Order 127.3, did direct that the bills not only be harmonized, but actually be republished before the House could transact them. Mr. Speaker, in the same vein, I want to plead with you, because 30th of June is still too far away, Mr. Speaker. The House can find a mechanism of navigating through this process, but we cannot circumvent a very cardinal process, a very cardinal principle in the Constitution of Kenya 2010, which is public participation under Article 118, Mr. Speaker, by simply rushing through this process. Mr. Speaker, it is my submission that this bill requires not only a harmonization process, but actually requires to be republished, so that the public can be given adequate time and opportunity to participate. Mr. Speaker, I submit. Thank you.
Majority Leader.
Thank you, Honorable Speaker, and may I thank the Leader of Minority for raising those issues. However, Honorable Speaker, a number of the issues that have been touched on by the Leader of Minority are not accurate. Because, Honorable Speaker, I have been in this House for the last almost 11, 12 years with the Leader of Minority. We joined this House together. And he knows for a fact, because he has alluded to previous rulings by Speaker J.B. Muturi and precedents set by Speaker J.B. Muturi. The Leader of Minority knows for a fact there is not any single moment that Speaker Muturi or indeed any other speaker in the history of this House has allowed the process of winnowing alluded to understanding order 131 on money bills. That is a fact, and the Leader of Minority knows that is a fact. Winnowing has been done on other bills except money bills that are not subject to Article 114 of the Constitution, Honorable Speaker. Therefore, in view of that, Honorable Speaker, that's what I was saying, Honorable Speaker, it is not accurate what the Leader of Minority is saying. And indeed, if this was not a money bill, a winnowing process would help to enable the House to process the myriad of amendments that are similar in a faster way. But on money bills, the Leader of Minority, with all due respect, knows in the history of this House, it has never happened, because money bills are subject to the provisions of Article 114. Two, Honorable Speaker, this is not the first finance bill we are processing as a House. Neither is it the last. But filibustering is also not the first time we have seen it. And it's not the last time we have seen it, Honorable Speaker. Therefore, Honorable Speaker, I hear the Honorable Leader of Minority say that we don't need the concurrence of the National Treasury. And to an extent, I agree with him. We are not under the directions of the National Treasury at all. But I want to confirm that in line with the provisions of Article 114 of the Constitution, the Chair of the Finance Committee has been able to engage, and even after the House Business Committee this morning, Honorable Speaker, I was in a meeting with the Chair of the Finance Committee and a whole delegation from the National Treasury to consider all the amendments that have been proposed both by the committee, and indeed, I can tell you there were clauses, amendments that have been proposed by the committee, which on consultation with the National Treasury, some were dropped. There are amendments. If you go through the supplementary order paper, Honorable Speaker, you will see the amendments by the member for Homa Bay, the Honorable Kaluma, that have been allowed following that consultation. The amendments by the Honorable Oundo, Honorable Naisula, who is seated right at the back, Honorable Mbui, Honorable Aluoch, Honorable Mule. Therefore, there are myriad of many amendments that have been allowed following that consultation. And therefore, that's what I was saying, it may not necessarily be very accurate to say that there are those that have been condemned and had. Two, Honorable Speaker, or three, the question of public participation. In the history of legislative processes in this country since the enactment of the new Constitution, Honorable Speaker, no other bill, none whatsoever, not even the infamous political parties bill, which we took through winnowing, none has had a more rigorous public participation exercise than this finance bill, Honorable Speaker. And I must commend the Chair and the Finance Committee and members who sit in the Finance Committee from both sides of the political divide, because I know there are diligent members of the Finance Committee in Azimio who sat through the public participation. There are many members within the Kenya Kwanza coalition who sat for long hours through public participation. For the first time, Honorable Speaker, I have seen members of Parliament, as Honorable Junet was saying, not just sitting up to midnight, sitting even on Sundays. At one point, Honorable Speaker, may the Lord forgive me, I was watching a public participation exercise when I was seated in church somewhere, Honorable Speaker, because these members of the Finance Committee devoted a lot of their time to this public participation. And therefore, the question of public participation, I think, is spent and is something that has been covered. Honorable Speaker, there are other amendments, and I'll draw reference to some amendments I've seen here by the Honorable Makali Mulu, some that seek to delete particular clauses, Honorable Speaker. I think, Honorable Speaker, other than being subjected to the provisions of Article 114, if you are seeking to delete a provision in a bill, the easier way is to vote against that particular provision in the bill. And therefore, you have been accorded the opportunity, since the provision is still the particular clause, for instance, those that the Honorable Makali Mulu sought to delete. The easier way is when we go to committee, the Honorable Makali Mulu will get an opportunity to prosecute his case as to why he seeks deletion and convince me and others that we should delete that particular clause. And if we agree with him, we vote in the negative and delete, basically defeat that particular provision, and it will not be there. Therefore, Honorable Speaker, let me in conclusion say that the process of winnowing in the history of this House, I think, is a fact that is known by those who have been here, that the process of winnowing has never been subjected to money bills. And unless we are trying to reinvent that, Honorable Speaker, and I do want, in conclusion, to beg that as much as we are not in a hurry, Honorable Speaker, as the leader of minority says, we have up to midnight. We are in no hurry. But we must also spend the time that we have devoted here up to midnight today, up to midnight tomorrow, up to midnight on Thursday, and hopefully even before 30th, any other day. But we must utilize our time properly. Let us not in any way utilize our time through filibustering and trying to spend time in not as a very wise manner, Honorable Speaker. I beg to submit.
Junet.
Mr. Speaker, the cardinal responsibility of this House is to legislate, Mr. Speaker, in Article 95. And Mr. Speaker, we must stop anything that can impede legislation in this House, Mr. Speaker. Mr. Speaker, the members here have amendments to the finance bill, but they have been told that under Article 114, there must be consultation with the Treasury. But Mr. Speaker, the consultation with the Treasury is supposed to happen between the committee and the Treasury, and not necessarily with the members. And this impedes now members from doing their legislation work, Mr. Speaker. Mr. Speaker, I remember in 2018, in this House, and it's on record, it is in the hands of Mr. Speaker, I brought an amendment to the finance bill, which was a money bill. And we were amending a clause that was putting, VAT, 16% VAT on fuel, the same thing we are doing today. And Mr. Speaker, at the beginning I was told that this is supposed to be under 114. But the Speaker then was seated on the same chair, you are seated today, made a ruling in the afternoon here, and said that let the matter be decided by the members themselves in a voting. And in the end, we agreed that let us come up from 0, we go to 8, and the executive comes from 16, they come to 8, and that's why today we have 8% of VAT on the fuel, Mr. Speaker. Mr. Speaker, there was no memorandum. There was nothing. We agreed here, and the Speaker ruled that he's exempting that amendment from what Article 114. Why? Because even the Constitution, that 114 says, in the opinion of the Speaker has an opinion. The Speaker has a serious opinion because he's the one who runs the House. He's the one who is in charge of legislation in this House, Mr. Speaker. He's the one who approves amendments. He's the one who looks at the constitutionality of matters that we bring to this House, Mr. Speaker. So, Mr. Speaker, first, don't lose what the Constitution has given you, which says in the opinion of the Speaker. It did not say in the opinion of the Minister for Treasury. It did not say in the opinion of the Minister for the PS for Treasury. Mr. Speaker, in your opinion, if a matter, if an amendment is of national interest, of national importance, Mr. Speaker, in your opinion, I beseech you, you should allow, members will do a decision here in one way or the other, Mr. Speaker. The amendment will be voted on, and they will decide on one way or the other. But in conclusion, Mr. Speaker, let me also add a pick from where the majority leader said, like what Honorable Makali has proposed in terms of deletion.
Mr. Speaker, I don't think voting against an amendment is the same as proposing an amendment of deletion, Mr. Speaker. Those are two different things. They are not the same. They are not the same, Mr. Speaker, according to the way I understand it. Deletion means getting rid of that thing in totality, completely out of the bill. But no means it can go either way, Mr. Speaker. So, Mr. Speaker, Mr. Speaker, even deleting you have to, that is why exactly you vote on the amendment and you also vote for the deletion, Mr. Speaker. And Mr. Speaker, deletion of clauses have been a tradition in this House, Mr. Speaker. The clerk here, before he became the clerk, he was the director of legislation and this other thing, what's called what? Legislation and procedure. And Mr. Speaker has been approving deletions for the last 15 years I've been here, or 10 years I've been here. Delete this, delete that. Why is deletion becoming an issue today? If you don't like that deletion, vote against it also. The way you are saying we vote against the amendment. Mr. Speaker, let us have here free, under the Article 95, freedom of debate and freedom of legislation. Let anybody bring any amendments they want, let it be put on a vote, and if the vote carries, whichever side carries the vote, we agree with it and we move forward. Mr. Speaker, let us not hide ourselves under Article 114. That article is so ambiguous. It's like the one that the executive uses to guard Parliament when we normally pass bills here. They go for assent. They return it with a memorandum, Mr. Speaker. And then you are told to undo that. You have to get 2/3. Article 115. That's another one. That has been abused for the last 10 years, Mr. Speaker. It was abused in the last 10 years. Mr. Speaker, you sit.
There's a point of order from Chepkonga. Yes.
Mr. Speaker, when Honorable Junet Mohammed repeats himself over, he doesn't need to convince anyone. He just filibustering here. What he just needs is to stay to be relevant to what he's saying. But, he looks at the majority leader, then he repeats the same thing he had just said 30 seconds. Mr. Speaker, you should rule him out of order. There's a standing order which is very clear, not being repetitive. And two, Mr. Speaker, he doesn't need to convince us too much. We know where he stands. Just he has to speak for 1 minute, and then he sits down, and then we will deal with the rest, Mr. Speaker.
Junet, finish, Junet.
Mr. Speaker, Honorable Chepkonga is my friend, Mr. Speaker. But these 5 years of absence from Parliament, Mr. Speaker, something must be done. But anyway, something must be done, Mr. Speaker. We must do something about it, I think. But let me leave it there. Mr. Speaker, in conclusion, I want to say that, Mr. Speaker, in your own wisdom and in your own opinion, Mr. Speaker, I beseech that we allow amendments that have been brought by the members so that we can proceed and vote on them and see how they go, Mr. Speaker. Thank you very much.
Murugara. Just take your seat, I'll give you. Murugara.
Thank you. Thank you very much, Mr. Speaker. Mr. Speaker, as we proceed, we must distinguish between money bills and ordinary bills. And there is clear distinction, even from our own constitution, as to what are money bills and what are ordinary bills. When it comes to standing orders on winnowing, it is very clear, and this is a house of record. We have precedents on where winnowing has been allowed, where harmonization has been allowed by the Speaker. We do not have any precedent in this House where winnowing has been called for and where this House, the Speaker has allowed for winnowing to take place. The reason being, money bills are actually special forms of bills which are contemplated during the budget-making process. This is where this House is appropriating money so that the government has revenue for its use. Even where you look at the Constitution, where it is stated in the opinion of the Speaker, it proceeds to say in sub-article 2 that that motion for a matter listed in the definition of a money bill, the Assembly may proceed as per recommendations of the Committee of the House after taking into account the views of the Cabinet Secretary responsible for finance. So surely, this is not far-fetched when we say we are to seek views of the Cabinet Secretary for Finance. It's part of our law. Most important, it's important to say that in the last parliament in which I sat, we did winnowing in the political parties amendment laws, which was in order. We also did it in the security laws, which was in order, but we have never done it in a finance bill. And most important, again, I go to deletions. Deletions in a finance bill are equivalent to successfully opposing a section of that act. Once you oppose successfully, that section is deleted in entirety. This is why we are saying there is no point in having these deletions in the order paper. We simply take it to vote. It carries the day, the deletion succeeds. It fails, the section remains. Therefore, we believe we should be proceeding without these deletions, and most important, the winnowing bit is not relevant to what we have before the House today. Thank you, Mr. Speaker.
Makali Mulu.
Yeah, thank you. Thank you very much, Honorable Speaker. Honorable Speaker, I want to go on record that I've been a member of the Budget Committee since I joined this Parliament for the last 11 years. And one of the key responsibilities of the Parliamentary Budget Office is to determine whether bills are money bills or they don't need to come to the Budget Committee. Once bills are determined to be money bills, Honorable Speaker, the Budget Committee will have to sit and accord a member a chance to present this bill and justify why the bill is important to this country. And on the basis of that, then there will be consultation with the Treasury to determine whether the bill should proceed to the second reading or not. Now, Honorable Speaker, what we have done to this bill, this being a finance bill, automatically all amendments will be money bills. All amendments will relate to money bill because this is a finance bill. Honorable Speaker, if you look at the kind of amendments being proposed by members here, and there are very many, Honorable Speaker, I think what Junaid was saying makes a lot of sense. That we might need to be accorded an opportunity as honorable members who are proposing these amendments to be listened to, so that on the basis of that, then we make a decision whether I need to withdraw my amendment or not. In a situation where you are leading more than 10 honorable members and two departmental committees proposing amendments, and we just want to rubbish this kind of amendment by the fact that they relate to Article 114, I think we have been unfair to this House, as a House which makes laws. So, honorable members, for me, we still have up to 30 to pass this bill. I don't think we are late. If it was my opinion, I would have requested that the Speaker accords us an opportunity, maybe up to midnight, as he's saying. Now we can just break and this committee convenes. We go there up to midnight, we present our issues, and then we see our way forward. The other issue is, when I propose to delete a clause, we know this House, matters voting, we lose all our senses. People will just say yes, even when it should be no. Others will be saying no when it should be yes. And on those basis, the only room I have is to delete, so that I'll have an opportunity to prosecute my case, and I hope I will be convincing some on the basis of objectivity and not on the basis of what we are being told to do, honorable members. So, Honorable Speaker, I beg you, if it is possible, you accord these honorable members an opportunity to prosecute our amendments. Thank you, Honorable Speaker.
Chair of the committee, I will bring this to a closure soon.
Thank you, Honorable Speaker. I have an advantage of having been a member of the Committee of Finance and National Planning for the entire life of the 12th Parliament, and therefore I have seen the process of the finance bill for the last 5 years, and this the 6th year where I have chaired. Honorable Speaker, on 2 occasions, I actually did not agree with the committee, and I wrote, and it was actually on the order paper, that I move amendment on the finance bill. And those 2 occasions, Honorable Speaker, there was no winnowing that happened for those particular finance bill for the 5 years that I served as a member of the Committee of Finance and National Planning. The Honorable Makali Mulu brings a very interesting debate about money bills and budget committee. So, and now that makes it even a little more complicated. Then, should therefore those amendments have been sent to the Committee of Budget and Appropriations and not then the Committee of Finance and National Planning? Lastly, Honorable Speaker, most of the amendments that honorable members were bringing, we actually did have a sitting with the committee, and we actually looked at them. And for some of those and most of those amendments were actually being carried in our amendments that you're proposing this particular afternoon, Honorable Speaker. And lastly, every clause, and I would like members to really understand this, that every clause in this particular bill has a financial implication. Last week, we did pass in the Committee of Supply, the appropriations of various categories. I did not see, Honorable Speaker, apart from the allocation for private universities, I did not see any amendment proposing to do a cut in any of the budget proposals that was passed by the Chair of the Budget and Appropriations Committee. Therefore, to expect, therefore, that the committee would accept particular clauses, or amendment of particular clauses, without consultation on the financial implication, would be committing a budget suicide, if we call it that, Honorable Speaker, because we have a responsibility. And unfortunately, that responsibility is being carried by the Committee of Finance and National Planning to find resources for projects, for votes that this particular House has agreed on. So I really urge this House, when you come to debate on the revenue measures to finance the budget you members of Parliament have already passed, which I do not see any of the members of Parliament on the other side of this House amending any vote to reduce our expenditures, to come and now reduce how we are going to finance this. We have tried to achieve a deficit of only 718 billion. Therefore, any amendment without consultation on any clause is therefore going to affect our debt and our...
114.
I think, Honorable Speaker, I have made my point. Thank you very much.
Honorable members, for us to make progress, having listened to the issues raised by the minority leader, the response of the majority leader, the Honorable Junet, the Honorable Makali Mulu, the Honorable Murugara, and the Honorable Kimani. First, the issue of Article 114 should be protected and be held as sacrosanct. However, in the opinion of the Speaker, and this is not in any way President setting against 114, having looked at the amendments listed and the clauses in the bill that have attracted the highest proposals for amendments, and these are the following clauses: Clause 2, Clause 24, Clause 33, Clause 34, Clause 36, Clause 43, Clause 76, Clause 78. I will allow proposed amendments on those clauses to proceed regardless. The rest, order. Those of you who have filed amendments, you know the clauses you are amending. In my view, and in consultation with my clerks at the table, the clauses that have attracted the highest proposals for amendment, and it will not be good to lock them out. I want those who have proposed to prosecute them, are clauses 2, 24, 33, 34, 36, 43, 76, 78. I'll allow, regardless of my views on 114, and I want to repeat, this is not a precedent setting. It is a unique situation that I'll allow the House, in the interest of fairness and in the interest of arriving at a consensual bill that takes our country forward. You will be allowed to prosecute your amendments, and Honorable Kimani and Honorable Majority Leader and the rest be available to prosecute this in committee stage. As we go into the committee of the whole, I want to say the following. Yes, Junet, what is it?
Speaker, in accordance with your ruling, Mr. Speaker, now that has changed the dynamics of our engagement, I'm requesting, Mr. Speaker, that we adjourn for 10 minutes so that we appraise our members on those clauses that you have given. Then we sit down again, Mr. Speaker.
Order. Yes, Ruku. Honorable Ruku.
10 minutes.
Thank you, Mr. Speaker, sir.
it is true the Crowd 71, Mr. Speaker, has ensured that this country has missed royalties from the year 2020 to now, from the year 2020 July to the moment. And if we are not going to...
Are you speaking to my direction?
Yes. If you are not going to allow this House, Mr. Speaker, to also look at the amendment... No, he has not mentioned Crowd 71. I beseech you, Mr. Speaker, to also allow Crowd 71 of the finance bill to be looked at, regardless whether it is a money bill or it's affecting Article 114 of the Constitution or not. Because if it does not get the amendment, Mr. Speaker, this country will continue losing royalties, and we are here seeking to see how we can finance the deficit of 719 billion. As it
Honorable
has been,
Ruku, you seem to have a mistaken belief that the amendment will go through. It will be put to a vote.
Yes, please, Mr. Speaker, I beg you to allow we put that clause into the...
You know, if I now start deleting and including, we will not make progress. I've given you a reasoned direction, and I believe it's a sound direction. Let me now call the House. What is procedural, Bandi? And let it be procedural.
Procedural. Mr. Speaker, I want to first of all thank you for your ruling and the indulgence on this matter of allowing members who had proposed amendments to be considered. But Mr. Speaker, as a matter of procedure, from the debate here, Mr. Speaker, it is clear that we need to do something about our standing orders and to make amendments. Mr. Speaker, I want to just suggest, because tomorrow we will have another speaker who may not indulge these members. We need to be clear that if this provision in the Constitution talks about Assembly may proceed only in accordance with the recommendation of the relevant committee of the Assembly, there should be a report from the committee on each and every proposed amendment so that members proposing amendments, Mr. Speaker, are not disadvantaged. It should not be left at the whim of the clerk or even the Speaker, Mr. Speaker. Mr. Speaker, by the way, you only have the authority, in your opinion, to determine whether it is a money bill. But as to whether the House should proceed, that is now supposed to come from the committee. And that should be in form of a report, Mr. Speaker. So what I expected, Mr. Speaker...
Mbadi,
yes.
You are actually pursuing a defeatist argument.
No, Mr. Speaker, I am just asking that we fine-tune our standing orders.
You are inviting me to lock out everything. Because, Honorable Mbadi, you know you are talking to a speaker who is also a very senior lawyer in this country and who understands legal issues very clearly. There is the provision of Article 114 and the public participation bit. There is also your own standing orders that limits the time within which to file the amendments. So if you want to open that argument and we go back to the status quo ante, then we lock out everybody. I have exercised my discretion and magnanimity to members who have filed amendments in the largest number and said, so that we do not lock out members unnecessarily and unreasonably, those clauses that have attracted the largest number of proposed amendments cannot be for nothing. Let them be dealt with in the committee of the whole. You will argue your case for amendment. The chair of the committee or any other member will respond. The chair of the committee of the whole will put the question, and the matter will proceed. Number two, going forward, because I have told you already, honorable members, and directed that you'll sit up to the end of the day, today, tomorrow, Thursday. But it's also in your interest to prosecute the matter and finish it within reasonable time. So the manner of voting, I will direct the chair of the committee that where he or she finds it necessary to call for an electronic vote to do so. Where it is necessary to go for a voice vote, I always call it a noise vote. If you want to have a noise vote, the chair will determine. Where you want to have an electronic vote, the chair will determine, so that you can make reasonable progress. So I now ask you to be upstanding. We go into the Committee of the Whole.
Order number 14, Committee of the Whole House.
Supposed to bow. I bow.
Did you bow?
Yes, I did. I did. Yeah, members, I already bowed and none of you are sitting. You may sit. We now commence the Committee of the Whole House.
Two. The Income Tax Act, Clause 2. Yes, amendments. We will proceed with this.
I now propose the question that Clause 2 be part of the bill. Mover to move the amendment. Chairperson.
Honorable Chair, I beg to move that Clause 2 be amended as per the supplementary order paper. And essentially what we're doing here, Honorable Speaker, is changing the definition of winnings relating to betting, gaming, lottery, prize competition. And this is where we are only allowing the profit made on that particular bet by tightening the law so that the only money that is allowed to be deducted from the amount staggered is the amount that pertains to that particular transaction. So, Honorable Chair, this is just tightening this on the law. This matter has been litigated in court, and we are just trying to make sure that it is aligned with the court ruling and defines the gains made on betting by specifying that only the amount that is going to be allowed to be deducted from the amounts waggered or staggered is the amount that was used for that. It is amount, not amount, that is used for that particular transaction and not transactions. And Honorable Chair, this also helps because there was a view that this could be abused, where if, for example, you place a bet of 1,000 shillings thrice and win after the fourth time, then what will be deducted will be the stakes that you've put the 3 times you've bet before. But Honorable Speaker, now this tightens up that particular law so that it's only the amount that is waggered or staked for that particular transaction. With that, I beg to move, Honorable Chair.
Honorable Peter Kaluma. Yeah. I now propose the question that Clause 2 be amended as proposed. Okay, yes. Yes. Honorable Kaluma.
Thank you, Chair. Chair, I beg to move that Clause 2 be amended in paragraph A by deleting the proposed new definition of person. Honorable members.
Are we mixing the two amendments? Are we mixing the two amendments?
No, I'm giving Honorable Kaluma an opportunity to contribute to that because he had a similar amendment. He had a similar amendment. So his was similar.
Yeah, Honorable Chair, is the amendment proposed on person? Because I heard the Chair, Honorable Chair, to speak about a different matter. If it is on person, I can contribute, Chair.
Yes, Honorable Kaduma, you had a similar
Yes.
amendment. Yes.
I thank you, Honorable Chair. Honorable Chair, I would agree with the committee to delete the definition of person for the reason, Honorable Speaker, that the definition proposed states that in the case of an individual, a reference to a relative, a person includes a reference to a relative as defined in Section 26, subsection 5. And on that Section 26, subsection 5 is a provision of the Income Tax Act. Honorable Speaker, when you look at that Section 26, subsection 5, that definition includes your ancestor. In fact, it begins with ancestor. Late relatives, deceased relatives, and so many people. It means you would be obligated, Honorable Speaker, Honorable Chair, to pay taxes for defaults even by your ancestors. And for that, I agree with the committee that it be deleted.
Yes, with the question. Yes, let's go to the next one.
Now you know.
I now put the question that clause 2 be amended as proposed by the chair. Yes. Will as many as of that opinion say aye? Aye. Will as many as of the contrary opinion say nay? The ayes have it. I now put the question that
Yes.
Honorable Nyikal. Yeah.
Thank you, Chair. My amendment in clause 2 is actually clause 2B, and my amendment is that clause 2B should be deleted. The import of this amendment, Madam Speaker, is that all issues of digital content monetization is under this, taking from A, B, C, D, E, F, all the way up to H. So, Madam Speaker, that means that all these activities that are now being subjected to tax, it is my view, and we have been saying here, that when young people are actually trying to use content to actually raise some money, we do not go ahead again and tax them. Therefore, my amendment is that B be deleted. That is my proposal, Madam Chair.
I now propose the question that clause 2 be amended as proposed by Honorable Nyikal. Yes, nothing. No, it's Honorable Badi. Yeah, Honorable Badi. It's on. No, he has put his name there.
Madam Chair, I would not have a problem in supporting this amendment, in so long as. But the problem is the moment we now remove the digital content, then we must make sure that the provision in law that is taxing them, withholding tax, will also fall. So if you ask me, I would support Nyikal's amendment so that we are silent completely on the issues of digital content in terms of taxation, so that we exclude this important sector, the digital content monetization, and what we call content creators, and social, and so to allow the young generation, people who are interested in, who are unemployed, but are trying to eke a living. So, Mr. Speaker, Madam Chair, I would request the House to agree with this amendment so that we remove the digital content monetization completely from this finance bill, which therefore means when it comes to the withholding tax, which we will come to at 15%, then now that will not be considered at all, because we have already removed from the definition the digital content monetization.
Chairperson for the Finance Committee.
Thank you, Honorable Chair. I think I want to make a clarification so that we move together. Honorable members, Clause 2 has three sections. Has Part A that talks about the definition of winnings, has Part B that talks about the definition of digital content monetization, and by the way, this does not talk about the rate yet. We are just defining, especially with reference to what crowdfunding is, and providing reference, so that crowdfunding is where you use, say, Mchanga or WhatsApp to raise money, say, for a particular cause. So this amendment is not seeking to tax the amount of money raised in that particular crowdfunding, but the fees that are going to be collected as an income monetization, so that they are able to tax. Then Part C, Honorable Osoro, this has three parts. It's important that we carry the members so that we know what we're doing. Part C is what Honorable Kaluma was talking about, deletion of persons. The committee has already proposed a deletion of that definition of persons that was giving liability to ancestors and family members and stepbrothers and stepsisters. So that is already, as per I moved, as amendment of Clause 2. With that, I wanted to bring the House to speed. I thank you, Honorable Chair.
Yeah, Honorable Chair, I was just letting you respond to the proposal by Honorable Nyikal. Then after that, I'll give you an opportunity to prosecute all your amendments as the Finance Chair. What's your point of order, Honorable Mbadi?
Madam Chair, what I wanted to say, because the proposed amendment is about digital content monetization.
Just put it in Oh, it's okay, Honorable Mbadi. If you're agreeing with me, then there's no need to. Just let him finish. You have a minute.
You say put the question,
Honorable
I don't even know what
Mbadi,
people are discussing.
You're out of order, Honorable Mbadi. Just finish. I've given you a minute.
Madam Chair,
Yes.
on the issue of rates, we will come to that. And the moment we are done.
Okay. Yes, thank you. All right. We've had you. Okay. I now put the question that Clause 2 be amended as proposed by Honorable Nyikal. Will as many as of that opinion say aye? Aye. Will as many as of the contrary opinion say nay? Nay. The nays have it.
Division.
Do we allow the division?
Yeah.
All right. Okay, we'll ring the bell for 5 minutes. Ring the bell for 5 minutes. And get all your cards ready. Get your electronic cards ready. Honorable members. Yeah, I want to read.